Okay, I'm reading Trusts, Chapter 6 in the Estates and Trust Cases and Materials, Stirk and Leslie's 5th edition, and Chapter 6. And I'm reading just Delaware statute right now, asset protection, Delaware's asset protection statute. So for definitions, as used in this chapter, disposition means a transfer, conveyance, or assignment of property, or the exercise of a power so as to cause a transfer of property to a trustee or trustees. And it skips to the 6th definition, which is qualified disposition, means a disposition by or from a transferor to a qualified trustee or qualified trustees with or without consideration by means of a trust instrument. Skipping to the 9th definition, qualified trustee means a person who, A, in the case of a natural person, is a resident of the state other than the transferor, or all other cases is authorized by the law of the state to act as a trustee and whose activities are subject to supervision by the bank commissioner of the state, the Federal Deposit Insurance Corporation, the Comptroller of the Currency, or the Office of Thrift Supervision, which has been absorbed into the Comptroller of the Currency or any successor thereto. And B, qualified trustee means maintains or arranges for custody in the state of some or all of the property that is the subject of the qualified disposition, maintains records for the trust on an exclusive or non-exclusive basis, prepares or arranges for the preparation of fiduciary income tax returns for the trust, or otherwise materially participates in the administration of the trust. And C, to further define qualified trustee, is for purposes of this subchapter, neither the transferor nor any other natural person who is a non-resident of the state, nor an entity that is not authorized by the law of the state to act as a trustee, or whose activities are not subject to supervision as provided in paragraph A of this subsection, shall be considered a qualified trustee. However, nothing in this subchapter shall preclude a transferor from appointing one, including but not limited to 1 through 3 advisors who have authority under the terms of the trust instrument to remove and appoint qualified trustees or trust advisors. 2 advisors who have authority under the terms of the trust instrument to direct consent or to disapprove distributions from the trust. And 3rd, advisors described in section 3313 of this title, whether or not such advisors would meet the requirements imposed by paragraphs A and B of the subsection. For purposes of this subsection, the term advisor includes a trust protector or any other person who, in addition to a qualified trustee, holds one or more trust powers. And D, D, under the qualified trustee definition, is a person may serve as an investment advisor described in section 3313 of this title, notwithstanding that such person is a transferor of the qualified disposition, but such a person may not otherwise serve as advisor of a trust that is a qualified disposition, except with respect to the retention of the veto right permitted by subsection 10b of this section. And F, under the definition of qualified trustee, is in the case of a disposition to more than one trustee, a disposition that is otherwise a qualified disposition shall not be treated as other than a qualified disposition solely because not all of the trustees are qualified trustees. The 10th definition in the Delaware Asset Protection subchapter is trust instrument, which means an instrument appointing a qualified trustee or qualified trustees for the property that is the subject of the disposition, which instrument A and B A transferor's power to veto A expressly incorporates the law of the state to govern the validity, construction, and administration of the trust. and B is irrevocable, but a trust instrument shall not be deemed revocable on account of its inclusion of one or more of the following. 1, a transferor's power to veto a distribution from the trust, and 2, a power of appointment other than a power to appoint to the transferor, the transferor's creditors, the transferor's estate, or the creditors of the transferor's estate, exercisable by will or other written instrument of the transferor, effective only upon the transferor's death. Third, the transferor's potential or actual receipt of income, including rights to such income retained in the trust instruments. 5. So I guess that's 5 under the trust instrument definitions. The transferor's receipt each year of a percentage not to exceed 5 specified in the trust instrument of the initial value of the trust assets or the value determined from time to time pursuant to the trust instrument, or of a fixed amount that on an annual basis does not exceed 5% of the initial value of the trust assets. And 6, the transferor's potential or actual receipt or use of principal, and such potential or actual receipt or use of principal would be the result of a qualified trustees or qualified trustees acting. B and C, A, and such qualified trustees or qualified trustees' discretion. B, pursuant to a standard that governs the distribution of paragraph. The cat's like confused what that noise is. Noise coming from the phone. Okay. What was I saying? B, I think I was talking about B. Pursuant to a standard that governs the distribution of principal and does not confer upon the transferor a substantially unfettered right to the receipt or use of the principal, or C, at the discretion of the advisor described in paragraph 9C of this section, who is acting in such advisor's discretion, or pursuant to a standard that governs the distribution of principal and does not confer upon the transferor a substantially unfettered right to the receipt of or use of principal. For purposes of this paragraph, a qualified trustee is presumed to have discretion with respect to the distribution of principal unless such discretion is expressly denied to such trustee by the terms of the trust instrument. 7. The transferor's right to remove a trustee or advisor and to appoint a new trustee or advisor other than a person who is a related or subordinate party with respect to the transferor within the meaning of Section 672C of the Internal Revenue Code of 1986, which is codified at 26 United States Code, Section 672C, and any successor provision thereto. 8. The transferors, and I think all these numbers like 5, 6, 7, and 8 further describe trust instrument when it's irrevocable. But a trust instrument shall not be deemed revocable on account of its occlusion of one or more of the following. So we're qualifying a revocable. We're qualifying an irrevocable trust. So in 8, the transferor's potential or actual use of real property held under a qualified personal residence trust within the meaning of such term as described in Section 2702C of the Internal Revenue Code of 1986 and any successor provision thereto, or the transferor's possession and enjoyment of a qualified annuity interest within the meaning of such term as described in Treasury regulation, and any successor provision thereto. See that the interest of the transferor or other beneficiary in the trust property or the income therefrom may not be transferred, assigned, pledged, or mortgaged, wherever voluntary or involuntary, before the qualified trustee or qualified trustees actually distribute the property or income therefrom to the beneficiary, and such distribution of the trust instrument shall be deemed to be a restriction on the transfer of the transferor's beneficial interest in the trust that is enforceable under applicable non-bankruptcy law within the meaning of Section 541C2 of the Bankruptcy Code, or any successor provision thereto. So the next section of the Delaware Asset Protection Trust is avoidance of qualified dispositions, Section 3572, followed by 3573, limitations on qualified dispositions, and 3574, effective avoidance of qualified dispositions. And then I'll stop because we go into problems. So, avoidance of qualified dispositions. A, notwithstanding any other provision of this code, no action of any kind, including without limitation, an action to enforce a judgment entered by a court or other body having adjudicative authority shall be brought at law or in equity for an attachment or other provisional remedy against property that is the subject of a qualified disposition, or for avoidance of a qualified disposition, unless such action shall be brought pursuant to the provisions of 1304 or 1305 of Title VI. The Court of Chancery shall have exclusive jurisdiction over any action brought with respect to qualified disposition. B, a creditor's claim under Section A of this section shall be extinguished unless the creditor's claim arose before the qualified disposition was made, and the action was brought within the limitations of 1309 or August 1, 2000, or notwithstanding the provisions of Section 1309 of Title VI, the creditor's claim arose concurrent with or subsequent to the qualified disposition, and the action is brought within 4 years after the qualified disposition is made. In any action described in Section A of this section, the burden to prove the matter by convincing evidence shall be upon the creditor. Like when the action or when the creditor's claim arose, and if it met statute of limitations or the date of the statute, I guess. D, under avoidance of qualified dispositions, is notwithstanding any law to the contrary, a creditor, including a creditor whose claim arose before or after a qualified distribution, or any other person shall have only such creditor, nor any other person shall have any claim or cause of action against a trustee or advisor described in